Today, my friends, welcome. We are timely for sure in talking today about the 14th Amendment. When the 14th Amendment was ratified in 1868, it marked a profound change in our Constitution. Following the abolition of slavery, the 14th Amendment granted to the federal judiciary and Congress new powers that safeguarded citizens' rights against state violations. It was through the 14th Amendment that African Americans were granted full citizenship. And it was through the 14th Amendment that this week we celebrated the 69th anniversary of Brown versus the Board of Education. This amendment's clauses were designed to ensure that all citizens are treated fairly and cover the privileges and immunities of American citizenship, due process of law, and equal protection under the law. Our guests today, esteemed professor of law, Randy Barnett and Evan Bernick, argue that the Supreme Court has long misconstrued or ignored the original intent behind the amendment's clauses. Together, we will listen to them and explore the history behind the 14th Amendment and its impact on civil rights from the end of the Civil War to the present. With our speakers' extensive knowledge, we will also discuss the formation of the Party of Lincoln and how the amendment went beyond abolition to incorporate small r Republican citizenship into the Constitution. And finally, our guests will provide valuable insight into the original scope of one of the most impactful amendments in the United States Constitution. Our featured guests are amazing legal scholars. Randy Barnett is a prominent legal scholar in constitutional law who serves as a professor of constitutional law at the Georgetown University Law Center. He's also the faculty director of the Georgetown Center for the Constitution and has taught as a visiting professor at Penn and Northwestern and Harvard Law School. Professor Barnett is a prolific author. We are honored to have you with us. His distinguished colleague, Evan Bernick, teaches constitutional law, criminal procedure, administrative law, and legislation at Northern Illinois College of Law. He was previously a visiting professor and executive director at the Georgetown University Law Center and a resident fellow at the Center for the Constitution. Professor Bernick clerked for Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit, so he's been in the mix dealing with the federal courts. We are honored to have this group. And as Sam described to you, these two scholars will tell us about what was going on when the 14th Amendment was passed, how has it been interpreted, what does it mean for us today, and we will return to the question and answers. Our folks are madly putting questions into the Q&A, so we'll listen to the two of you for probably about half an hour, a little bit more, and then we'll have plenty of time for questions and answers because suddenly this 14th Amendment has become the hot topic of the day. So we appreciate very much you both being with us. Professor Barnett, are you going to start?
Yep, I'll kick it off.
Okay,
so thank you, Jane, for inviting us. Thank you for that wonderful overview of the 14th Amendment. It was very nicely done. And it provides a great opening for me to continue on in discussing the broad features of the 14th Amendment. But before I do that, because our book, which by the way, this talk is going to be based on the original meaning of the 14th Amendment, its letter and spirit, is originalist. I thought I would talk a little bit about originalism, what originalism is, because I think many of the people in the queue in the audience might have a misconception about what originalism is. And then I'm going to talk about why it doesn't matter whether you're an originalist to appreciate what we're talking about here. So originalism can be summed up in a single sentence. and that is that the meaning of the Constitution should remain the same until it's properly changed by amendment. The meaning of the Constitution should remain the same until it's properly changed by amendment, and that means that the Constitution, being the law that governs those who govern us, those who are to be governed by the Constitution, should no more be able to change the laws that govern them without going through the amendment process than we, the people, can change the laws that they make to govern us without going through the legislative process. So that's what originalism is. And our book is about understanding what the original meaning or the original public meaning of the words of the 14th Amendment were in context when they were promulgated. What would those sentences have meant at the time they were promulgated? And that meaning is what's fixed until it's properly changed by amendment. But having said all that, it isn't necessary for people to agree or to accept originalism as their approach to interpretation to still find what we have to say about the original meaning of the Constitution vitally important, because almost every person who's interested in the Constitution, almost every constitutional law professor, thinks that the original meaning of the Constitution is at least something that needs to be taken into account. It's at least something that you need to know about before you decide whether, for example, the constitutional meaning has evolved since then by judicial decision. If you believe in living constitutionalism, you at least need to know what the Constitution was, the meaning of it was when it was adopted, how it might have been changed since then, so you know what that is. And so most constitutional law professors are what you might call pluralists. They believe there's a variety of different considerations that need to be taken into account, but they do think that the original meaning of the Constitution is one of those. And if it's one among many considerations, you want to get that one right. You want to be accurate about that one. And that's what our book is about. It is what is the original meaning of the 14th Amendment. So when we think about originalism or the original meaning of the Constitution, many of us think about the founding. When the Constitution was originally drafted. And as you know, the founding era is now problematic or controversial because of the various original sins that existed at the time that the American government was founded, that the American regime was founded. Most prominently that of slavery. There is also the legal subordination of women that existed at that time and for some time afterwards. And so so our focus on the original meaning of the Constitution, if it's limited to the original meaning of the text of the Constitution at the 14th Amendment, originalism becomes quite controversial because of that. But the original meaning of the Constitution today is not the original meaning of the Constitution in 1787 or 1789 when the original document was formed, or 1791 when the Bill of Rights was added. The original meaning of the Constitution today is its original meaning as amended 27 times, including the Bill of Rights. And those amendments have had a profound change on the text of the Constitution, on the original meaning of the Constitution. And you can't really understand the meaning of the Constitution we have today without taking into account all of those amendments. But perhaps the most important, after the Bill of Rights, perhaps the most important amendment that has been added to the Constitution is the 14th Amendment. The 14th Amendment was added by the Republicans in Congress, proposed by the Republicans in Congress after they had adopted and passed and gotten ratified the 13th Amendment, which had abolished slavery. That was, of course, an amazing accomplishment, something that even critics of slavery believed the Constitution needed to be amended in order to end it, and it was successfully accomplished in the 13th Amendment. And it was at that point in our history that a kind of massive resistance arose to the rights and liberties, the privileges or immunities of the freedmen who had been released from bondage and were now being subjected to a panoply of legal regulations and restrictions on their liberties, short of complete and total chattel slavery, so skirting around the prohibition of the 13th Amendment, but which had what's known as the badges and incidents of slavery. That is, these were taking away, for example, their freedom of labor, and other vital liberties. The right to keep and bear arms was being deprived systematically by Southern militias. In response to that, Congress passed a civil rights law, the Civil Rights Act of 1866, which made illegal any of these violations of these fundamental privileges of citizenship that belonged to the freedmen. But there were two things about that. One is some people questioned the constitutionality of the Civil Rights Act, which was passed under Congress's power under the 13th Amendment to bar slavery. That act was vetoed by President Andrew Johnson on the grounds that, well, this is not an act about slavery. This is an act about other things. The 13th Amendment doesn't allow for this. The Republicans disagreed. They overrode Johnson's veto, but nevertheless, there was a doubt raised about the constitutionality of that provision, of that statute. And more important, the Republicans were concerned that when Democrats returned to the Congress, they would repeal that statute as they had promised to do. And so they thought, many Republicans in Congress thought that it was necessary to have another amendment that would enshrine the privileges or immunities of citizens of the United States, as well as access to the courts and other legal rights that all persons have, even if they're not citizens of the United States. It was important to enshrine that into a constitutional amendment that could not be repealed, and also to give an additional power to Congress to enforce those laws, which would then have made the Civil Rights Act of 1866 unquestionably constitutional. And Congress reenacted the bill after the 14th Amendment was adopted to ensure that it was constitutional, but would also give Congress the powers to protect other individual rights of citizenship that might be breached by the states. And so what the 14th Amendment represented was a fundamental shift of our system of federalism. Up to that point, states had so much inherent power to regulate. This is known technically as the police power. They had police powers that were so great that they could authorize the ownership of some people by other people. That's how great and powerful states were under our original constitutional scheme. The 14th Amendment represents an important textual qualification of our original federalism, creating a kind of new federalism in which states still retained a vast police powers to regulate for purposes of the health and safety of the public, which they do. But those health and safety regulations needed to be scrutinized or vetted in case they would violate the privileges or immunities of citizens of the United States, the fundamental rights of citizens of the United States. And then a new federal power was created both to enact laws like civil rights laws that would prohibit states from violating these privileged immunities in the course of exercising their vast police powers, and also that you could go to court and you could sue. And because the 14th Amendment was the higher law, that you could actually sue to vindicate your rights in federal court, getting yourself out of the state court system. So our federalism, the federalism that we have today, was fundamentally altered by the 13th, 14th, and then eventually the 15th Amendment, which prevented discrimination in voting on the basis of race. But most importantly, the 14th Amendment altered our system of federalism to create a federal check on abuses of individual rights by states that just was not part of our original scheme. And to be an originalist means to be respectful and believe we should follow the whole Constitution, not just the original Constitution, but the Constitution as amended. I want to now turn this over to my colleague and co-author, Evan Bernick, and to talk about the concept of Republican citizenship, which Jane mentioned in her introduction, because it is this concept that developed historically during the debate over slavery that led to the formation of the 14th Amendment. It led to the 14th Amendment taking the form that it did. And so it's really important for us to understand historically what this concept was. And so now we'll let Evan explain that concept to all of us.
So I have to say that I was very intrigued by the framing of this event, which I think was something along the lines of the Revolution of 1868. At any rate, the word revolution was in there somewhere. which raises an interesting ontological question. I plugged revolution into the Oxford English Dictionary just before I logged on, and I found that revolution is defined as a forcible overthrow of a government or social order in favor of a new system. And in this context, it would be the overthrowing of existing constitutional order and the replacement of that constitutional order with a new and different system of government, if we are taking this understanding of revolution literally. I don't know that Randy and I would go so far as to make that claim. Randy's framing of it, of the Reconstruction amendments, reconstruction rather than revolution, as fundamentally altering the system of government that we have, I think is quite apt. But I think also that what we show in our book is that the content of today's Constitution, its text, its structure, wasn't somehow determined by the Constitution that we had in 1787, even if we're prepared to say that it's all the same system of government in some fundamental respect. So today's Constitution isn't a butterfly to the 1787 Constitution's chrysalis. There are many other possible futures, other constitutional futures that could have arisen from the system that we had in 1787. And I want to talk about a particularly disturbing one that was very much available during the antebellum period, and which I don't think lost out because of the 1787 Constitution. Rather, it lost out because of politics, the politics of radical abolitionism, later the Republican Party, and, as Randy has anticipated, the concept of Republican citizenship that social movement was able to use to fundamentally alter the Constitution of 1787. So this disturbing future. This is a future in which the slave power became sufficiently entrenched across the federal government that it was emboldened to do what Republicans feared reasonably that it would do after Dred Scott v. Sanford. Dred Scott held that enslaved people were property under the Constitution and that the federal government couldn't interfere with that property. And Republicans feared that the next step the court would take was to hold that states couldn't interfere with slavery either. This future didn't happen, but we don't have the Constitution of 1787 to thank for it. We have, looking at the history of antebellum contestation over slavery in the halls of Congress, the pulpits and conventions of free Black people who agitated for their full citizenship, in streets and ultimately on the battlefields, to recognize how easily things could have turned out differently. Now, Republicans who framed and campaigned for the ratification of the 13th, 14th, and 15th Amendments and used it to advocate for transformative constitutional change didn't always agree, to put it mildly. But they didn't disagree as much as you might think. They were largely of one mind on a core concept that they wanted to embed in the Constitution beyond all doubts. It wasn't one that they came up with on their own. It was heavily indebted to radical abolitionism. But it was in important respects unique enough to call it Republican citizenship. And to understand Republican citizenship, you first have to ask the question, what is a citizen of the United States? The 1787 Constitution doesn't say. It refers to natural-born citizens and citizens of the several states. But the concept of national citizenship isn't expressly stated, and it's definitely not defined or elaborated. But there arose during the antebellum period an intuition that some set of fundamental, non-negotiable rights needed to follow anyone who was a citizen of any state everywhere they traveled. And that intuition became more pronounced as it became clear that certain of those rights were not as secure against state infringements as the framers might have hoped that they would be. This notion of a stable set of national fundamental rights had deep roots in English law and politics. To be an English subject was to be understood to be entitled to certain rights that Sir William Blackstone referred to as privileges and immunities. And these included rights like the right to due process of law, the writ of habeas corpus, trial by jury, and other rights that were deeply rooted in the common law everywhere. You can think of these rights as being tried and true means of securing underlying natural rights to life, liberty, and property. They weren't themselves natural rights. They were positive rights that English people had long deemed so essential to human freedom and to equality between equal subjects that they were considered fundamental, non-negotiable. So there are no juries in the state of nature, but you needed them to preserve your natural freedom in a civil society, therefore a fundamental right to trial by jury that follows your status as a British subject. Now, Americans didn't always have nice things to say about Blackstone, but his conception of citizenship, of civil rights that attached as such to a certain status within a polity, found traction among radical abolitionists like Joel Tiffany, like Alvin Stewart, Lysander Spooner, Sarah Grimke, and James Burney, who argued for a similar conception of civil rights that attached to American citizenship, not subjectship, citizenship. And these arguments were picked up by Republicans like Joshua Giddings, John Bingham, Salmon Chase, Lyman Trumbull, Thaddeus Stevens, and Charles Sumner. And radical abolitionists tended to argue that the federal government had the power to protect any fundamental right anywhere, including in enslaving states, during the antebellum period, mind you, before Dred Scott, and that slavery was therefore everywhere unconstitutional because it violated every fundamental right. Republicans tended to argue that slavery could be banned only in federal territories. So Republican citizenship meant the enjoyment of civil rights that were deeply rooted and widespread, that protected natural rights, that ensured civic equality between similarly situated citizens, and also a commitment to making states rather than the federal government the primary enforcer of civil rights. The federal government could intervene only in the event of state failure to protect these fundamental rights of national citizenship, and only as empowered by the Constitution. So precisely how, following the battlefield defeat of the Confederacy, the federal government needed to secure fundamental rights on a national scale proved an object of heated debate. After the ratification of the 13th Amendment, some Republicans contended that no further amendment was needed for Congress to secure Republican citizenship. But as Randy has explained, a number of Southern states responded to abolition by trying to reproduce slavery by facially neutral, operationally discriminatory criminal laws known as the Black Codes, and by leasing out to private employers Black people who were convicted of crimes who were then worked to death. And so thanks to this convict leasing, as well as other kinds of public and private violence in the former Confederate states, it became apparent that more federal intervention to secure citizenship was needed. But there were certain disagreements about whether additional constitutional authority was needed to underwrite that intervention. President Andrew Johnson's veto of the Civil Rights Act, which targeted the Black Code, strengthened the bargaining position of Republicans like John Bingham, principally John Bingham, who argued that additional constitutional authority was necessary to remove any doubts that we can enact legislation like this. And eventually, John Bingham, who argued all along for another amendment, won the day. An amendment principally drafted by Bingham himself was presented to the House and the Senate. So what did it say and what did it mean? This amendment that is now fundamental to constitutional law in the United States and receives the brunt of attention from people across the nation whenever the Supreme Court sits. I can't summarize all of our claims that we make about the 14th Amendment here, but I do want to summarize what was widely considered to be the most important part of this amendment and why it promised to those who ratified it and future generations a constitution truly worth celebrating, whether one wants to think of it as an entirely new one or something that is fundamentally continuous with the Constitution of 1787. I realize I'm saying fundamental a lot. So the part I have in mind is the Privileges or Immunities Clause, which reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." In what, for reasons I'm glad to discuss, time permitting, is a reliable exposition delivered to the Senate by Michigan Senator Jacob Howard. Howard stated that the privileges and immunities of citizens of the United States couldn't ever be exhaustively described, but he did describe two categories of privileges or immunities of citizenship. In the first category, Howard said, were the privileges and immunities spoken of in the second section of the fourth article of the Constitution, which confusingly enough is the Privileges and Immunities Clause, Article 4. And Howard then read a very lengthy passage from an influential judicial opinion in the 1823 case of Corfield v. Coriel, interpreting the Privileges and Immunities Clause as a guide to the meaning of the Privileges or Immunities Clause. In Corfield, Justice Bushrod Washington defined the privileges and immunities protected by Article 4, Section 2 as rights which are in their nature fundamental, which belong of rights to all citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union from the time of their becoming free, independent, and sovereign. And he went on to explain that privileges and immunities may all be comprehended under the following general heads: protection by the governments, the enjoyment of life and liberty with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. And then he said that under these general heads fell several rights that aren't listed in the first 8 amendments, what we now call the Bill of Rights, or elsewhere in the Constitution, including the right to travel, to be protected by the government, to be free from discriminatory taxation. Now, after reading from Corfield, Howard then identified a second category of fundamental rights. He says, to these privileges and immunities, whatever they may be, for they are not and cannot fully be defined in their entire extent and precise nature, to those should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. Howard said that the great object of the first section of this amendment is to retain the power of the states and compel them all times to respect these fundamental guarantees. In our book, Randy and I contend that this was the meaning of the Privileges or Immunities Clause that is now part of our Constitution. What Howard said in the Senate, Republicans said on the campaign trail, and newspapers reported. This is a meaning forged in the heat of social movement contestation over citizenship, in the crucible of barbarous oppression. Black Americans were lynched. Their white allies were shot while defending their printing presses, driven out of southern cities, mobbed even in northern cities. This oppression didn't stop when Lee surrendered, didn't stop with the 13th Amendment. The need to expressly empower the federal government to act on convictions about national citizenship that most abolitionists had always held but lacked the political power to achieve was so pressing that even the more conservative and moderate Republicans, men like John Bingham, could appreciate it. But Randy and I talk about the fact that the promise of the Privileges or Immunities Clause has yet to be redeemed. The Supreme Court, in a series of decisions, effectively removed it from the Constitution, holding that it protects only a handful of insubstantial rights, like the right to access sub-treasuries, over which nobody fought a war, probably not any war. Some, but not all, of the rights listed by Howard have been protected instead through another provision of the 14th Amendment, the Due Process Clause. So it was originally regarded as the most important rights protecting provision of the 14th Amendment is the least important rights protecting provision in contemporary constitutional law. And we argue that the nullification of the Privileges or Immunities Clause is a grave injustice. It's an injustice because it undermines a provision that is really central to our Constitution's moral legitimacy. A Constitution without everything that is promised by the 14th Amendment really invites hard questions about whether any given law that makes it through our constitutional system can be presumed to be morally legitimate. The gaps the 14th Amendment fills are hugely morally important, and if we don't get the 14th Amendment in full, they don't get filled. And second, it's an injustice because it obscures the efforts of countless people, both known and unknown to history, to get this specific language in the Constitution. This text is proof that a constitutional system that was once relentlessly used to dominate and subjugate can be made to deliver the blessings of liberty that it has always promised. People fought and died to turn the Constitution, if indeed at one point it was not, into a glorious liberty document, as Frederick Douglass called even the antebellum Constitution. And they fought and died for this promise of citizenship, grounded in fundamental rights that have proven their worth as shields against oppression. So our overarching message is this Constitution is good because it was made good. And if we don't say that and explain why and give effect to what people fought and died to get into it, we dishonor the dead as well as endanger the living.
Thanks, Evan. I see that a lot of people in the queue have asked about the debt limit issue and Section 4 of the 14th Amendment, and I want to say a few words about that in a minute. But before I do that, I don't think the practical importance of the 14th Amendment can be overstressed, and I do think it's completely unappreciated. And I'll just put it this way. If you make a freedom of speech First Amendment challenge to a state law, or a free exercise of religion challenge to a state law, or you assert a right against unreasonable searches and seizures by states or by a subordinate level of state, like a municipality, if you make any claims like that at all, those are not, strictly speaking, First Amendment claims or Fourth Amendment claims, or the right to keep and bear arms. That is not strictly against a state, is not strictly speaking a Second Amendment claim. It is a 14th Amendment claim. By all accounts, these are rights that are protected by the 14th Amendment. No, you don't get to federal court to enforce your Bill of Rights claims without the 14th Amendment being there. So what we think of as First Amendment claims against the state are really 14th Amendment claims. Then the debate is, what's the clause of the 14th Amendment that authorizes that? Evan and I believe it's the Privileges or Immunities Clause. Modern Supreme Court doctrine says it is the Due Process Clause, but everyone agrees that it's a 14th Amendment that gets you there. So it's hard to imagine one provision that could be more important than the 14th Amendment, given our culture of protecting constitutional rights. Now, let me address the debt limit issue, which is on the minds of people and probably is responsible for why we have such a great turnout on the webinar today. Let me begin by saying Evan and I are constitutional scholars. We are not political pundits. And we constitutional scholars of any kind, tend to reserve judgment until they've examined the evidence. And Section 4 of the 14th Amendment is not covered in our book. It's not something that we did research on. Our book is primarily about Section 1 of the 14th Amendment and the scope of the enforcement powers of Congress in Section 5. We don't really talk much about Sections 2, 3, and 4. And so we can't speak as scholars, and that means we can't speak very forcefully on this topic. But I can say this: the obligation of the federal government to honor its debt, as claimed as stated in the 14th Amendment, Section 4, is not a power of the president to incur additional debt. It is not a power of anyone to incur additional debt. So it doesn't justify taking on additional debt in order to satisfy either new spending or old debts. It does, if it obligates the federal government to do anything on its face, it obligates the federal government to allocate its revenues in the form of taxes and other revenues it has to the satisfaction of the debt, and not to renounce that debt. If it does anything at all, then it does that. But it doesn't have much to do with a debt ceiling limit, which is supposed to limit the ability to incur future debt. But I've already prefaced this by saying, I'm kind of speaking now as kind of what I kind of derisively call armchair originalists. Armchair originalists are those who just look at the text, think they know what it means, and then run with it. It is very common, even for law professors, to do this. And so it's only due to popular demand that I feel I should address this at all. But my armchair originalism tells me that the Section 4 of the 14th Amendment doesn't apply to the debt ceiling crisis controversy at all. But I would await and keep an open mind to hear from scholars who have studied that matter more closely than I have or than Evan has, to convince me otherwise, because you have to maintain an open mind if you're going to have a fact-based interpretation of the Constitution.
Evan, would you like to add your perspective, since, as Professor Barnett says, you're both in an armchair scholar, but yet still a scholar?
So I'm going to be even more humble than Randy and just not opine directly about any contents of the debt limits and the meaning of Section 4. What I will say, however, is that the very existence of Section 4, as well as Sections 2 and 3, reveals that the 14th Amendment should be understood not narrowly as a as a guarantee of judicially enforceable rights, but as an example of constitutional politics, a constitutional political economy that involved, for Republicans, not just protecting certain rights that they believed valuable, but ensuring the stability going forward of a government in which they would enjoy a structural advantage as a consequence of the transformations that they were effecting within it. So we think of the 14th Amendment and we think of the Constitution very generally as something that this is what courts do. But the Constitution speaks to a great extent about constitutional structure, and the defects in the constitutional structure are central parts of what Republicans were trying to fix through the 13th, 14th, and 15th Amendments, to try to transform it from a structure that enabled people to make credible claims that this was a slaveholders' republic into a structure that was able to facilitate what W.E.B. Du Bois called abolition democracy, and the greatest, one of the greatest episodes of human emancipation in human history.
I see a number of great questions in the queue. Let me address two of them that has been sitting there for a while. The first is the relationship of the Declaration of Independence to the abolition movement, as well as to the 14th Amendment. The Declaration of Independence was crucial. It sets out the American theory of government at the Americans' founding in 1776. The Constitution did not found the United States. The Declaration of Independence founded the United States. That is our founding. And in that founding, it states the American theory of government. And the American theory of government is, first, that we should all of us are born equal and enjoy certain inalienable rights, among which are life, liberty, and the pursuit of happiness. So it's an affirmation of what we call natural rights that we get by not by virtue of government, but by virtue of our humanity, and we're endowed by our Creator. And then secondly, here's the American theory of government. To secure these rights, government is instituted among men, deriving their just powers from the consent of the governed. So it states the purpose of government to secure these rights, and that is what became known as the police power of the states, was to secure the pre-existing rights of we the people. Government acts to make us better off than we would be in the state of nature. We leave the state of nature to get the protection of the government, the equal protection of the government. And so you notice that in my talking about the equal protection of the government, and also fundamental privileges of being that civil rights, when you leave the state of nature, you get civil rights in exchange for your natural rights. This all presages or previews what eventually became explicit in the Constitution in the 14th Amendment. As I think the questioner realizes, the Declaration of Independence was strongly relied upon by opponents of slavery in the decades that led up to the Civil War. It was one of the #1 arguments against slavery, to the point where Southern sympathizers eventually had to dismiss the Declaration as what one commentator referred to as a farrago of nonsense. That's how inconvenient the Declaration of Independence was. And in Dred Scott, Chief Justice Taney had to misread the Declaration of Independence and impose upon it an ahistorical view of what its meaning was in order to dismiss it. So that's a very important issue that has been raised by the questioners here. And I just forgot the second question that people have asked about.
Professor,
yes.
You're doing a great job of trying to pull everything, but I can try to pull the questions so you can be thinking about the answers. If that is helpful.
That would be great. I just happened to see another question, but now I can't remember what that question was. So I'd be delighted if you continue to pull questions for us.
We're happy to do that. I mean, one of the sort of consistent questions is the role that Thaddeus Stevens played when he was talking about, the issues that Professor Bernick raised about. We've got radical abolitionists. What's the range of that, and where?
That was the question. I forgot. You just put your finger on the question. The different flavors of abolitionism. I'll let Evan talk about Thaddeus Stevens in particular, but the different flavors of abolitionism what the people that are famous now as abolitionists are called the radical abolitionists, associated with William Lloyd Garrison, who was a Massachusetts newspaper editor. And they were radicals insofar as they believed that the Constitution was a covenant with death and an agreement with hell because it sanctioned slavery. They burned copies of the Constitution during their rallies. They advocated the dissolution of the United States to allow the free states to be separated from the slave states. And they opposed all political action as being immoral and unjust, and therefore didn't vote for candidates that they thought favored slavery. They wanted to withdraw from politics. They were so radical, particularly with burning the Constitution, it so turned off the general public, as you can imagine, that other anti-slavery forces did not want to call themselves abolitionists. So some historians now reserve the term abolitionist just to those radicals because other anti-slavery people didn't want to call themselves abolitionists because they didn't want to be associated with them, but they were every bit as much abolitionists as the radicals were. They simply believed that the Constitution could serve as a useful means to attacking slavery. So they're sometimes called constitutional abolitionists. They also believe that political power in the form of forming political parties could be used to abolish slavery. So they're sometimes referred to as political abolitionists. They formed, Salmon Chase first among them, who ultimately became Chief Justice of the Supreme Court, nominated by President Lincoln, helped form the Liberty Party, which was a pure anti-slavery party, which was succeeded by the Free Soil Party, which was a less radical party. And finally, that was succeeded by the Republican Party. All of these parties were formed by the same group of political and constitutional abolitionists. The one thing that Evan has already mentioned to you, but it may have been overlooked, is that the constitutional abolitionists were themselves divided. Some of them, like, for example, Lysander Spooner, and I'm just drawing a blank on not Wendell Phillips, like Lysander Spooner, believed that slavery was unconstitutional everywhere in the United States, that even Southern states that still had slavery, that still preserved it, could be ruled against because it was unconstitutional. That was a minority position amongst these constitutional abolitionists. Most took the view of Salmon Chase and others that slavery was constitutional in one of the original states that still had it, only in one of the original states that still had it. That's the reason why you needed a 13th Amendment. But on the other hand, slavery could be abolished in any free state, and all the free states abolished it already. Any state could abolish slavery, and it could also be abolished. Congress had the power to abolish it in the District of Columbia and in any federal territory or any federal installation. That was a very radical program for its day, and ultimately it became the political platform of the Liberty, Free Soil, and the Republican parties when they took power, which explains why the South seceded from the Union before the Republicans could take control and implement this anti-slavery policy of abolishing slavery everywhere, except in one of the original states where it still existed.
And can you try to put in context how the 14th Amendment interacts with the Civil Rights Act and the Voting Rights Act of the 1960s, and why those acts, had to come forth? And, as we look now, there's a lot of conversation about things that are going on in states that may be causing difficulties for people to vote, that there are things going on in states that may limit the opportunities for people who are LGBTQ. And how does the 14th Amendment interact with those kind of activities?
Evan, you want to take this? Talk about the Civil Rights Act of 1875?
Sure. So in the so-called civil rights cases decided in 1883, the Supreme Court held unconstitutional the Civil Rights Act of 1875, which was a statute that prohibited racial discrimination in places of public accommodation. The court said it would be running the slavery argument into the grounds to declare that no distinction shall be made between citizens of different race or color, or between those who have and those who have not been slaves. And in so doing, the court drew upon the slaughterhouse cases, which, as I've mentioned, took a very narrow view of the privileges or immunities of citizenship. So the civil rights cases, together with the slaughterhouse cases, effectively established that the 14th Amendment didn't protect very much in the opinion of the judiciary, and also that Congress didn't have the power to take a different view. And what ultimately happened as a consequence of these holdings was, besides licensing as a constitutional matter Jim Crow for decades, is that it shaped the strategy of civil rights activists and legislators who were aligned with them, who wanted to protect people of color against discrimination without running up against the civil rights cases, against precedents that would get their work held unconstitutional. And ultimately, the Warren Court, in upholding the Civil Rights Act of 1964 and its restrictions on discrimination in places of public accommodation, didn't overrule the civil rights cases. It said, we don't need the 14th Amendment, we've got the Commerce Clause. And it used the Commerce Clause theory to justify congressional power to prescribe discrimination in places of public accommodation. I think that Randy and I agree that this really does a disservice to the constitutional reasoning and really the moral reasoning that underpins the move to enact the Civil Rights Act of 1964. If you look through the legislative records, you can see in real time legislators saying, this is really about preventing racial discrimination. It is not about economics. And the response being, the Supreme Court is going to strike this down if we adopt this theory. And so as a consequence of the pressure that the Supreme Court effectively puts on the original meaning of the Constitution, in order at the time to facilitate the rise of Jim Crow and capitulate on Reconstruction, entire constitutional jurisprudence is distorted for decades, and the civil rights cases have still not been overruled. So the courts, the Warren courts, got around to undoing some of the damage that the Supreme Court did, but at the cost of really not relying upon the most powerful historical arguments that did justice to the moral gravity of the claims that were being made against racial discrimination and the statutes that were designed to prevent it.
So what you're saying is that because of the way the Supreme Court ruled on the original Civil Rights Act, that established precedent that caused us to have to enact new civil rights legislation in Congress, and the Supreme Court chose not to overrule the previous precedent, but instead to find a new path to make that possible.
Right, and because those who litigated this thought that asking the Supreme Court to do that, to overrule its previous decision, would result in a loss. And they didn't generally want to challenge the authority of the Supreme Court at a time when it was aiding the civil rights movement to the extent that it ever did in the wake of Brown. One can totally appreciate the strategy, and I think it was a good one given the constraints, but you can still lament that those who litigated it had to be put in the position of making an argument that got what they ultimately wanted indirectly in a way that didn't enable the courts, because it discouraged it from really engaging with the force of the constitutional objections to discrimination in places of public accommodation. This is a privileges or immunities clause case. The Supreme Court should have upheld the Civil Rights Act of 1964 on the basis of the fact that the right not to be discriminated against in places of public accommodation is a privilege or immunity of citizenship in the United States. Instead, we got a Commerce Clause decision.
And just to let me underscore, the biggest evidence that that's true are the people that supported the 14th Amendment also supported the Civil Rights Act of 1875, right, which was a sweeping ban on discrimination in public accommodations throughout the country, not limited to the South. And so it's the Civil Rights Act of 1964 was precedented. It was precedented by the people who gave us the 14th Amendment. They gave us a very comparable Civil Rights Act, and it was the Supreme Court that struck it down, and it stayed struck down until a new political movement could arise powerful enough to get another one enacted.
And several folks are asking questions about, has the 14th Amendment got anything to do with the whole question about abortion, bodily, integrity?
All of the cases concerning abortion, Roe versus Wade, Planned Parenthood versus Casey, and even the Dobbs case that was decided by the court 2 terms ago, these are all 14th Amendment cases. So the 14th, by all accounts, everybody agrees these are 14th Amendment cases. They are decided under the Due Process Clause of the 14th Amendment, that says that no person shall be deprived of life, liberty, or property without due process of law. And so that may or may not be the right place to analyze the question, but they're all 14th Amendment questions. And what happened in Dobbs, which reversed Roe versus Wade, Dobbs itself was not an originalist opinion. It was not based on the original meaning of the 14th Amendment. Justice Alito's opinion was based on a conservative reading of the Due Process Clause, so as to restrict the number of unenumerated rights that judges could recognize. And so that is how that's how Roe versus Wade got reversed. But all of these cases are 14th Amendment cases.
I'll comment on Thaddeus Stevens since there's an appetite for it. Thaddeus Stevens is an incredibly important and in many respects a tragic figure. He became a symbol of the Republican cause as a consequence of getting beaten on the floor of Congress by Preston Brooks for criticizing slavery.
That was Charles Sumner. That was Charles Sumner.
Oh, sorry, mistake. Thaddeus Stevens, however, like Charles Sumner, was one of the architects of what we now think of as radical abolitionism. And the 1875 Civil Rights Act was kind of an expression of where the radicals were actually able to take the Reconstruction Congress in general, not because they were able to get everything that they wanted. For instance, Thaddeus Stevens favored the confiscation of enslavers' estates. That didn't happen. But we're nevertheless able to open the window of discourse to measures that by any stretch of the imagination must be considered radical. I mean, we're talking about the transition from slavery to full citizenship for millions of forced laborers. This required massive economic redistribution. Stevens lost on the confiscation of enslavers' estates, but he won on the Second Freedmen's Bureau bill, despite it ultimately getting vetoed by Johnson, which authorized the distribution of food and clothing, tasked the Bureau's education division with constructing and staffing common schools, funding and authorizing the land division to purchase and reserve unoccupied public lands for destitute, loyal refugees and freedmen. I mean, this was radical stuff, and it was able to carry majorities in Congress precisely because of the passion and the vision of Stevens and Sumner and their courage.
Let me add one more thing to this, and that is that the Civil Rights Act of 1875 did not include desegregated public schools, did not bar discrimination with respect to schooling. That was because there were supermajority requirements in both the House and the Senate. Republicans were on record with strong majorities debating this measure early on. For about 4 or 5 years, the Civil Rights Act was under consideration. And finally, to get it passed, they eliminated the school provision of the non-discrimination law. But Brown versus Board of Education was preceded by this effort to keep this in. And the way that the bill finally got passed was after the death of Charles Sumner. His colleagues passed it as a tribute to him because he'd been working so tirelessly for this Civil Rights Act for so long that upon his death, that's what finally pushed them over the edge, and they passed it.
Now, we are coming on our time, and as you can imagine, there are a million questions. What we've done sometimes is we've asked our speakers, would you do a short overtime when we end? I don't know what your schedule is. Are you interested in doing an overtime, or shall I give you the last question?
I can do a little bit of an overtime. How much of an overtime do you need?
10 minutes max.
That would be great.
You're okay. So we're the wonderful nonprofit organization, so we always have to do our what we call the NPR moment. The these amazing public history webinars are brought to us only because of the support of our members and contributors. And we want you to know that these scholars are contributing their time and their talent. It is absolutely an amazing concept. And when you get your information that says, here's how you can get the webinar, you'll also have information about how to get the book. And so if you want to really delve into this and learn much more about what Professor Barnett and Professor Bernick want to do, you'll have information about how to order the book. So you have the book right there available. And we do hope that you will consider becoming members of the United States Capitol Historical Society and stay with us. So now we're in overtime because we recognize some of our folks have to go back to work, but some of them are going to take 10 extra minutes. And I'm going to take a little bit of liberty because people are still completely confused about what you said or didn't say about the debt ceiling. So let me tell you what I heard you say, and then you can say you are close, not close, out of your mind. What you said is there are 5 sections to the 14th Amendment, and the 4th section is the one that potentially addresses the debt limit. And that's not one that you delved into deeply, so you don't have the same level of analytical experience that you do with the others. But your armchair reading is that section 4 was put in to make sure that the debts that were paid, that were incurred during the Civil War would be paid, and that they would never be questioned, and that the debt of the government would not be paid, that there's not clarity in your mind that there's anything in section 4 that would allow the government to create new debt to pay old debt. And that question could potentially be litigated in any debt ceiling conversation. And so your armchair reading says, this thing says you got to pay the debts, but it doesn't say you got to go borrow some more money to pay the debts.
Yeah, that's right. That's a good summary. You're a great summarizer, by the way, Jane. You're a
Well,
great listener.
I listened to you.
You're a great listener. Not everybody is. The section 4 that we're talking about reads as follows: the validity of the public debt of the United States authorized by law, including debts incurred for the payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. That basically says that the validity of the debt, that debts will not, the way I read that in my armchair originalist fashion, which I have already said is not the way you should do originalism, but it's by popular demand here. I read that as saying that Congress cannot repudiate existing debt. Repudiating existing debt does not empower Congress in any particular way. But it particularly does not empower the president. That is what this debate is about. Can the president somehow unilaterally incur additional debt not authorized by Congress in order to satisfy either existing expenditures or to make debt payments? And I think that there's nothing in the 14th Amendment that would empower the president to incur additional debt. It is simply stating that existing debt needs to be honored, and there is more than ample tax revenue to honor existing debt. So there's not there. So I'm just going by what it says, and that's all I can do at this point because we haven't done a deep dive into it beyond that.
Well, let me really thank you for stepping outside of your comfort zone. We know that this is not your core thing. So let me ask 2 more questions.
Can I just mention this? When you're a constitutional law professor, this stuff arises like instantly. I mean, this 3 weeks ago, no one was talking about this. Now everybody's talking about this. If you consider yourself a scholar, it's not like you can go back and retroactively do all the scholarship you need to answer some point of current public controversy that hasn't been debated before, until now. And so it does put us in an awkward position, but there's a lot of law professors, shall we say, who will still rush to the microphone or write op-eds on the basis of something that they only know about off the top of their head. And that might be a better opinion than nobody. Maybe my reading of this is better than other people's reading of this, but I think we have to separate that kind of opinionating from that kind of opining from actually being a constitutional scholar. The book that that I held up earlier is published by the Harvard University Press. It's a scholarly book about the meaning of the clauses that we did study, which are the ones that are foundational to modern constitutional law.
Well, thank you. And so let's turn it to, given what you did study and the issue, there still are many discussions about equal protection and about what is going on, where there are many people who believe that some of the state laws or state practices are not providing equal protection. What do you see as the role of the 14th Amendment in today's activity about the balance between the state and federal governments?
Evan, you want to take that?
The Supreme Court sometimes gets things wrong, and citizens and legislators who disagree with what the Supreme Court says about the Constitution are not thereby being lawless. The abolitionists who challenged Prigg v. Pennsylvania and Dred Scott and sought to elevate to political office as many people who would act on the premise that those cases were wrongly decided as possible, we're not thereby defying the rule of law. So if Congress, in response to a Supreme Court decision, wants to assert a different view of the scope of the 14th Amendment, and in particular the Equal Protection Clause, I think that there's actually authority for the proposition that it can do so under Section 5. Section 5 distinctively empowers Congress to take the lead in defining and protecting constitutional rights. Can't make them up out of nothing, but if the Supreme Court, as for example, just to take a relatively uncontroversial example, although not entirely so, in Employment Division v. Smith holds that under the Free Exercise Clause, a neutral, generally applicable law that significantly burdens somebody's religious exercise is constitutional so long as it's neutral and generally applicable. And Congress says, we don't agree with that. In order to protect free exercise, we are going to require, in effect, strict scrutiny for any significant burdens on free exercise rights. I think it's entirely appropriate for Congress to be able to do this. And the Supreme Court has, in a number of decisions interpreting Congress's authority to define and protect constitutional rights, I think, gone too far in judicializing the 14th Amendment.
Well, just to take that one final way, and then I'm going to give you each your last word. So, but for this, you've spoken to Congress has that right. Yeah. We are in a situation where often the attempt to secure the rights comes from citizens who are seeking to secure their rights because they feel that they're being violated by the state government or the local government, and they don't see Congress as providing that protection, and they seek the courts as an alternative path to providing that protection. I
think it's fine for them to do so. The worry with focusing on litigation is that ultimately any litigation of constitutional consequence is going to be subjected to the rule of stare decisis, of precedence. So if a lower court judge upholds a constitutional claim that is almost certain not to be recognized by the Supreme Court, they're going to get reversed. And that doesn't mean that the enterprise is useless. It can serve a broader purpose of highlighting the injustice of existing case law, but it also needs to be, in a world with scarce resources, you also need to think about the utility of doing something like, if you think that the Supreme Court has wrongly, as I think it has, interpreted the Fourth Amendment or have nothing to say about discriminatory traffic stops, What you can do, instead of asking the Supreme Court to reverse itself on this issue, which it's probably not going to do, or taking the claim into federal court when it's going to obey the Supreme Court, you can move to have your city pass an ordinance that prohibits pretextual traffic stops. And then you're doing the work of enforcing the Constitution outside the courts without depending upon the courts. And that doesn't prevent you from also making the argument that Ren v. United States was wrongly decided, and we should appoint justices who think so.
Jane, I realize in light of Roger Walke's question here that we didn't really say much about the due process of law or the equal protection of the law, which are the other two major parts of Section 1 that we spend whole parts of our book talking about. So let me just very, very briefly discuss what the meanings of those clauses are. We've been talking about the Privileges or Immunities Clause because that's where the substantive rights of individual citizens finds textual protection. But the Due Process of Law Clause is primarily about the role of the judiciary. It's about the role of it requires that state judges, that states provide the due process of law, which means at least two things. One is that people who are accused of violating the law get a procedure, get a judicial hearing that would ensure that they are in fact guilty. So you need a reliable judicial process. You should have a day in court to prove or to be proven guilty or not in front of an impartial tribunal. And secondly, the due process of law requires that you only be held criminally responsible or legally responsible for violating a law that is valid, a law that was within the just powers of the legislature, the police power of a legislature to enact. So you ought to be able to contest the constitutionality of a law in court. And it's the due process of law clause that gives you the opportunity to get a judicial hearing on whether your fundamental rights have been violated. The final thing is the equal protection of the law clause, which is where much civil rights today is located, rather than in the Privileges and Immunities Clause where it belongs. But the equal protection of the law clause was a very important clause about the protection of the law. You could have perfectly valid, non-discriminatory laws, and still local law enforcement looks the other way when some people attack other people, like, for example, during the widespread practice of lynching. There were murder statutes on the books in the South that were fine, except that local law enforcement didn't enforce those laws. The equal protection of the laws clause, the equal protection of the law, it requires that states enforce the law equally, which they may not do. And Section 5 of the 14th Amendment empowers Congress to step in and protect the rights of individual citizens when the states fail to do so. And that's what Congress did in a series of civil rights laws. So if equal protection of the laws clause is what creates an affirmative duty on the part of government to provide each person with protection and a power in Congress to step in and perform that duty if states fail to do so.
That was a very good summary. So let me give you, here's your last, if you were going to say in about 3 or 4 sentences, what should someone, there's now, all of a sudden, the 14th Amendment has become the popular thing because everybody wants to talk about it in terms of the debt crisis. If you were at a, dinner table and someone said, okay, you're a scholar, what is the most important thing about the 14th Amendment? I want you each to give me your, as you say, elevator speech on why does it matter today?
I'll let Evan go first on this.
It's proof that within our constitutional system, social movements for radical change, including movements for racial equality, can succeed by kind of a all things are available strategy consisting of organic grassroots organizing, litigation, legislative action, all things operating within a constitutional system. I wouldn't go so far as to say that it by itself makes the Constitution morally legitimate in a culture that worships the Constitution, but it proves that you can do good things with it. And that may not be everything that advocates of social justice want, but it is something. It is valuable, and it's worth preserving and honoring.
I would emphasize that the Constitution that we have today is not the Constitution of 1787. It is the Constitution that has been altered in fundamental ways. And the most important way it's been altered by the 14th Amendment is by placing a federal check on the power of states to violate the fundamental rights of their own citizens, their own people, citizens and persons within their jurisdiction. That was a power that did not really exist at the founding. There is a contracts clause, but it's very limited. Otherwise, it did not really exist at the founding, and is something that created a change. And the Constitution that we live under today, the one that is either legitimate or not today, is the amended Constitution, not the original Constitution. But in order to understand whether the Constitution today is legitimate or not, you first need to know what it means, what it says, and that meaning is, in fact, its original meaning. So I return now to originalism as the mechanism for discovering whether what the Constitution says in order to determine whether the Constitution is or is not legitimate.
Well, this has been a fascinating conversation. Professor Barnett, Professor Bernick, we really appreciate you being with us. And for all those of you who are still on, we are determined to continue to work through the amendments. And we have a range of scholars from various different perspectives as we work through what does it mean to amend the Constitution, and why was it done at the time? How has it been interpreted? And we invite you to share with us your thoughts, your ideas. We are looking for a continuing conversation with a variety of perspectives, because the government that we have is stronger when people offer their opinions, they engage, and they participate. So we look forward to this. It will be available by video. If you're interested in the book, you'll have information on the book. And the next one coming up is the 15th Amendment. And we have a couple of asks out. And as soon as we get the confirmation about who's going to come, we will share that with you. Thank you very much. Thank you both.
Thanks for having us.
And this has really been great.
Bye.